Welcome to the Wellness Law Podcast, where wellness and the law meet for contemplation and collaboration. This podcast is brought to you by the Center for Health and Wellness Law. I am your host, Barbara Zabawa. Welcome, Gretchen, Carlson, and Julie Roginsky to the Wellness Law Podcast. I am thrilled, absolutely thrilled to have you guys here to talk to me and my audience about your work at Lift Our Voices. Everyone, I want you to meet Gretchen Carlson and Julie Roginsky. Gretchen is a fierce, fearless, and internationally recognized advocate for women's rights, whose bold actions against Fox News Chairman Roger Ailes helped pave the way for the global Me Too movement. She's a former CBS News and Fox News journalist, author, TED Talk alum, and champion for workplace equality, and was named one of Time Magazine's 100 most influential people in the world. Julie Roginsky has long been an outspoken champion of women's rights and issues. She's a nationally recognized political consultant and began her career working at the prominent organization dedicated to electing more women to political office. Throughout her career, she has focused on her efforts on mentoring and empowering women to become engaged in the political process. Welcome, Gretchen and Julie.
Thank you.
Thanks for having us.
Awesome. So let's just start with the Lift Our Voices organization. Tell us what it is, its mission, how you founded it, when.
Yeah, so really simply, I came forward almost 10 years ago already now at Fox News about sexual harassment, not knowing what was going to happen when I jumped off the cliff. But I realized there were two epidemics, not only the epidemic still of sexual misconduct in the workplace, but the epidemic of silencing people through things that we all sign in our contracts and we have no idea what they are. And thousands of women started reaching out to me and telling me the same kind of story where they had finally got the courage to come forward. They went to HR, for example, and they immediately were forced into secrecy, either through a non-disclosure agreement or through something called forced arbitration, which most people have no idea what that is. I know you're a lawyer, so you do, but most people don't. What that means is you can't go to court. You can't go in front of a jury of your peers, and instead you're going to be behind closed doors with an arbiter, which is most often picked by the company, and you never are going to win. The stats are horrendous. And then you get pushed out of the company for having courage. And what we have found is that most people never work in their chosen profession ever again. So that's pretty daunting news. And so I realized that I wanted to do something about that, to turn a really horrible situation in my life into something good. And so I started advocacy on this mission. And the first step was to go to Washington, D.C. to try and get legislators on board to get rid of forced arbitration and NDAs for these kinds of events. Now, I'm making it sound easy. It wasn't. It's been a very long journey. We have passed 2 bipartisan laws as a result of this work. But I'll go now to 2019 when Julie reached out to me, and that's when we formed Lift Our Voices.
And what brought me to this fight is that shortly after Gretchen filed her lawsuit, I did the same, and I had a very different trajectory. I decided I wanted to just go back to my life and not focus on this very dark time in my life until, unfortunately, I realized that can't be. When you do something like this and you come forward, it really does change every aspect of your life for good and for bad. But I want to stress for good as well, because I think a lot of people might think that this kind of ends your life, ends your career. Quite the opposite. For me, and I think for Gretchen as well, it really gave us purpose as to what we wanted to do with our lives. I came to this not just because of Fox News and my experiences there, but I came to this because I had a client who had also bound me to a very strict NDA that I did not realize was actually as strict as it was. I did realize it was as strict as it was when a young rape survivor came to me and told me she'd been raped in this organization. And she begged me for help. And I could not help her to the extent that I wanted, because I was reminded every single day by attorneys for this organization that if I were to help her, I would be sued into oblivion. That is just a devastating moment. I think probably the most devastating moment in my professional career, because here you have somebody who desperately needs your help. You can help them, but at the same time, you have to contend with the fact that if you do help them to the extent that you want to, you will be sued for violating your NDA. And at that point, I realized this can't go on. Nobody else should be going through this, not the survivor and not the witness who could help her. And that's when I called Gretchen. I knew that she was already deeply involved in this work. She had done so much incredible advocacy work with respect to forced arbitration on the Hill. And I called her and I said, listen, let's team up and do something about this with respect to NDAs as well. And so we did. And that's how we founded Lift Our Voices in 2019. And it's been just the defining, I think, moment and experience of both our lives, aside from our children. to know that we are doing something that will help just the millions and millions of women and men who will never meet, but nevertheless will benefit hopefully from just not only the law changes that we're pushing, but also the cultural changes that we're really trying to embrace.
I'm glad you mentioned the cultural changes because that ties back into what a lot of people who listen to this podcast are interested in, which is workplace wellness. And I think it's really important for everyone in the wellness community and workplace wellness in particular to understand the importance of the work that you guys are doing. Workplace wellness, we're all about making sure employees thrive in the workplace and that they have access to healthy meals and exercise and all those wonderful things. But if there are so many employees who are suffering from a toxic work environment, from sexual harassment, and then they have legal impediments in exercising their rights to address those workplace structural problems, then our wellness efforts are completely for nothing. They're going to be canceled out. They're going to be washed out by these underlying problems. And so the workplace wellness community has to be involved in these efforts that you guys are championing. And so thank you for that. And I really want to get to the laws that you guys have championed, the Ending Forced Arbitration Act and the Speak Out Act. So either one of you want to address or discuss what those laws do specifically?
Yes. And let me first, Barbara, just say that not to be cynical, but companies like to brag that they're transparent and that they want their employees to all be well and healthy. But the basic fact that they silence their employees, 84% of all employees in America right now are under forced arbitration, meaning that they do not have their Seventh Amendment right of going to a jury of their peers, and they're going to be silenced. 1/3 of all Americans sign NDAs on the first day of work, having no idea it includes anything that happens to them on the job, good and bad. So it's like a ruse, if I can be so honest. The companies can say how great they are and how much they're there for their employees because they know nothing's ever going to get out. All their dirty laundry is hidden. And so that was the impetus for us to try and change laws, because we realized that the only way we're going to force companies to have to own up to all this is to force them to do it. And the way you do that is to change the law. So the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, known as the EFAA, was passed 4 years ago now. And this was an effort that took us 6 to 7 years because we had to get both parties to come together on this. So basically what it does is it eradicates forced arbitration and the secrecy around sexual misconduct in the workplace. So even if you have a forced arbitration clause in your contract or your handbooks or any other workplace papers, you do not have to abide by that if you are facing harassment or god-awful rape in the workplace. You can go to a jury of your peers, but you have to know that. The company's not going to willingly tell you about this law. You can find out more at our website, liftourvoices.org. But that was the first law that we passed March 3rd, 2022. So it applies to any sexual misconduct after that date and time. And then the Speak Out Act was signed into law by President Biden a short 8 months later, because we used the same coalition of lawmakers we had worked with to say, hey, the second evil is NDAs. And I'll let Julie talk about the Speak Out Act.
Yeah, the Speak Out Act tried to address the same, it did address the same issues with respect to sexual misconduct. And it applies to pre-dispute NDAs. You might wonder what pre-dispute NDAs are. That's a great question. I mean, we would argue that pre-dispute NDAs are any NDAs that you sign on the first day of work or even before your first day of work, all the way through to when you get your right to sue letter from the EOC or when you file a lawsuit. But it remains up to the courts to determine whether that interpretation is correct. Nevertheless, we've done a tremendous amount at both the state and federal level to make sure that people can speak up. At the federal level, we passed the Speak Out Act, which applies to sexual misconduct for pre-dispute NDAs. But at the state level, we were able to get much more done. New Jersey was the first state in the nation to ban NDAs for all toxic workplace issues. California went next, and Washington State went after that. We're working on legislation in a bunch of other states, including in New York, in Connecticut, in New Mexico, and Oregon. And it is so important to do this at the state level, and I want to explain why. It's not just about people who live in those states. I'll use Microsoft as a really good example. Microsoft is based in Washington State. Washington State is a relatively small state. Microsoft is an incredibly large company. And when this Silence No More Act, which is the name of the NDA ban in Washington state, passed, the Silence No More Act applied to everybody working at Microsoft headquarters in Redmond, Washington. Microsoft did the right thing. They decided they were not going to create a two-tiered system. And what they did was they effectively created a paradigm where if you work for any part of Microsoft anywhere in the world, you are no longer bound by NDAs in compliance with their national and international headquarters. That means that these state laws have tremendous impact. Apple did the same in California. If you work at Apple in Omaha, Nebraska at an Apple store, you are no longer bound by NDAs under the California law. Despite the fact that it didn't need to do that, Apple did the right thing there. And those are just two examples. So these state laws have tremendous impact, not just nationally, but internationally as well.
Well, I applaud your efforts both at the federal level and the state level. And I really want to make an appeal again to the workplace wellness community that the legal detriments to well-being, which is what I'm going to call this, is the impediments to being able to speak out, to exercise your rights when you are in a toxic work environment, is so incredibly important to fulfilling the promise of well-being. That as wellness professionals who may be listening into this podcast, I would implore you to make the knowledge and the education of these important acts, the Ending Forced Arbitration Act, the Speak Out Act, and the implications of those acts on people's rights as part of your wellness training, as part of your wellness advocating in the workplace. Because the word has to get out. As Gretchen pointed out, it's up to the employee to know that they do not have to go through arbitration to exercise their right to protect themselves from sexual harassment. They can get help or legal remedies through a court of law and in front of a jury, which is so vitally important to well-being. I would encourage you to go to listourvoices.org and learn more about these acts and use the information there and incorporate it into your well-being programming. I'll certainly be advocating more for that. I also wanted to ask you guys, just going through your website, there's so much there, Lift Our Voices, but you also are involved in research. Can you talk a little bit about some of the more impactful research projects you've been involved in and things that you've learned?
Yeah, let me just also add first, Barbara, that as an organization, we fight for all protected classes. So even though we've accomplished these two federal laws for sexual misconduct, we fight for gender, race, disability, age, LGBTQ+, any kind of protected class discrimination as well. So we do have another bipartisan bill on the federal level called the Protecting Older Americans Act to get rid of arbitration for age discrimination. That has passed out of the Senate Judiciary Committee last Congress. And so we continue to work as hard as we can to check off the mark for each protected class along the way. So I want to be clear that we're not leaving everyone else out there to fend for themselves. We're trying to get this done for everyone. With regard to research, yes, it's instrumental to our cause because quite honestly, nobody gave a damn about researching any of this stuff because nobody cared about any of this stuff until the Me Too movement. And so we have done research. Probably the biggest research has been on our Ending Forced Arbitration Act that just came out that shows that people are actually getting justice now as a result of this law passing. And people can learn more about this at our website under the header #LoveJustice. It's a testimonial video campaign of actual people who have benefited from our law. And I'll let Julie talk about another really important NDA ban law in New Jersey about the research results there.
Yeah, as we talked about, one of the barriers to getting these NDA laws passed is that a lot of advocates, and not just people who oppose this, but a lot of advocates believe that if you don't have anything to trade for a settlement, like your silence, that you won't get a settlement. And we wanted to study that to see if that was accurate. So we looked at New Jersey's law because New Jersey was the first state in the nation to ban it. And about 4 years after New Jersey's law went into effect, we studied what the impact was. And what we learned was from having spoken to, and we had Penn State do this study, from having spoken to both employees and employers and attorneys for employers, is that there was zero impact on not just settlements, but the amount of settlements that you get. So having an NDA does not mean that your company will not settle with you. It doesn't mean that the amount that you're settled for is going to be less if you're not signing away your silence. And that is just something that I think most people did not realize. I wanted to see if the research bore this out, and it turns out that it did. Same thing happened in California. Stanford University did an expansive study about a California law that banned sexual misconduct in 2019, interviewed thousands upon thousands of employers and employees in LA and looked through legal settlements in LA County. And what they discovered was that, again, in Los Angeles County, there was absolutely no impact whatsoever. That is the largest study of its kind in the nation. It's a quantitative study there as opposed to ours in New Jersey, which is a qualitative study. All this to say that research and empirical data shows very clearly that you can do the right thing, both as a survivor and as a company. And there is going to be zero impact on you, any negative impact on you for doing the right thing. So from a cultural perspective, you should just go ahead and do it and not worry about it.
Wise words, and that's great precedent to know. I think we could extrapolate that to other areas where we might fear that the worst is going to happen. And those studies show that those fears are unfounded. So that's really great news. So I guess it's sort of to wrap things up. Do either of you have any advice to the wellness community that may be listening on how they might go about addressing some of the issues that we've talked about today, the harassment, the discrimination in all? And I love, Gretchen, that you made sure that you're trying to help everyone, but you're doing it one chunk at a time. How can they best proceed with the knowledge that they can gain from your website when they're dealing with individuals in the workplace who aren't doing well because of structural issues, toxic workplaces?
Yeah, if they're employed by the company, they're in a bind to help people because companies don't want to let you know that they're trying to silence you. So that's the uphill battle that we're against every single day. So our main thing is to educate people. For anyone who's listening, look at your employee handbook, look at any emails you clicked on, look at your workplace contract if you have one, see if you have something called a forced arbitration clause that handles all disputes. I guarantee you probably do. See what your confidentiality clause says, see what your non-disparagement, another way of saying NDA, clause says. It'll probably sound pretty flowery, but rest assured, it probably includes more than just trade secrets at the company, which, by the way, we think companies should be able to keep that stuff secret. That's their right. But they've just become so expansive to include anything else that happens to you. So education for us, Barbara, is really the key because we always try to say that it's analogous to paternity leave or paid family leave. 15 years ago, that was frowned upon because not many men, frankly, took it because it was frowned upon. Now, more and more men have started to do it. We've normalized it. We don't frown upon it. And it's become a part of our culture. That's what we're trying to do with silencing mechanisms. The more that people understand them, the more they start asking questions about them, the more they come together in peer-to-peer networks and go to HR and say, hey, do you think we could do mediation instead of forced arbitration? It's a fairer process. The more then we can start to change the system. We understand we're not naive. We understand it's a big hurdle to get big, huge companies to change their policies. But this is the way we can really affect change, we believe, if we start at the grassroots level, and knowledge is power.
Thank you. Julie, did you have anything to add?
Just that we are deeply committed to ensuring that this is just a cultural phenomenon that changes. We need to look at this completely differently than we've been looking at this from day one, which is that this is the paradigm between people who are, on the one hand, employees, on the other hand, employers, and there's a constant tension there. There is not a constant tension there. We need to make sure that we work in tandem together because productivity rises when you have a happy workplace, and it doesn't happen otherwise.
Amen to that. Absolutely. Again, thank you both so much for your time today. I really appreciate everything that you're doing and you spending time talking with us about your work at Lift Our Voices. Please, everyone, visit liftourvoices.org. You can donate, you can learn, and of course, support them in any way you can because they are doing part of the work that's so vital to employee well-being. So thank you guys again.
Thanks.
Thank you for listening to the Wellness Law Podcast. You can find more wellness law resources by visiting the Center for Health and Wellness Law website at www.wellnesslaw.com, where you can also subscribe to our newsletter and follow us on social media. Until the next episode, stay well, stay hopeful, and stay legal.